I'm just going to get the preliminaries out of the way. We'll get started in about 10, 15, 20 seconds more, exactly at 12:30 Eastern Time. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community call. You have already understood that this call is being recorded, so be careful about the information you give out. You may want to conceal your identity. Now, the way I will do it, as usually I always do, I will read through the questions that have been posted on the forums, and once I'm done with those, I'll ask people if they have any follow-ups on those questions. Once we are done with those, then we'll take new questions. We'll have enough time to take new questions, so no worries, everybody's questions will be answered. And I have budgeted enough time, so we'll be able to make sure that everybody gets their questions answered. Okay. Now, the first question is from UNVA. University of Northern Virginia was asked to be shut down, and this is because of the irregularities or their inability to comply with the state requirements. So the question that has been posted from Arvind 543 is that he had applied for his OPT extension. The question is, what about the people who are already on OPT extension if the school is being closed? What would be the best approach? Join another college, apply for H1 next year, etc. Well, if the school's credentialing is taken away, obviously that degree doesn't mean anything. And if it is not a degree school, I believe that ICE will not allow the school to issue I-20s or to continue to maintain OPT. Although, come to think of it, there are schools that can issue I-20s without being credentialed. So I'm not sure what ICE wants to do with this. Until ICE comes out and says that they are revoking or decertifying the school from the I-20 program, people who have their OPT extensions already in hand, I think they can continue working. I have a similar question here from one of our clients, Preeti ji, who they have an employee who's in a similar situation. So the first answer is that if you already have OPT, until the OPT is revoked, I don't see why we cannot continue to use it. Okay. As to the question that has been asked by Arvind 543 on the forums, what would be the best approach to handle? Should I join another school? I think so. And apply for H1 next year. That's what makes sense to me. So transfer your service account over to another school. That does make sense. Preeti ji had an additional question. I got an email from them about a half hour ago. So I said I'll just discuss it in an open call rather than charge a consultation for this. So the question was, this company, when they applied for their employees H1 in this year's quota, they did it as a master's degree quota application because at that time that seemed to be the right thing to do to them. Then subsequently they got a denial of the H1 because the university was not issuing recognized master's degrees. So the question is, can we now apply under general quota? And the answer is no, because the quota is gone. Okay, I think I've covered these issues. Let me go on to the next question, which is Philly 3456. They have a green card perm audit going on. There's a 10-day period between H1 maxing out and their ability to extend for the 7th year. So there's a 10-day gap. Yeah, you can go to Canada, I think. That would be a good way to do it. Because for Canada, you don't need a visa. And as long as your I-94 is valid, you can come back. So don't apply for a visa. Just go to Canada for 10 days. Make sure that you have some record. Do some credit card purchasing there. Whatever else you can do to establish presence in Canada for 10 days. And then come back using your I-94 and the process called automatic visa revalidation, AVR. AVR says if you have an I-94, we'll let you come back in if your trip is less than 30 days and you have not applied for a visa. So just go take a couple of weeks vacation to Canada. That way you can add that on to your next year's H1. So you'll get your 7th year H1 without having to go outside USA. That's what makes sense to me. Caliber 91. So they have an I-130 appeal pending. So the question is, this is a spouse of a US citizen. His wife filed for his green card. Can I continue using your EAD, using my EAD even though the I-130 485 is under appeal, it was denied? My answer to that question is, there are two schools of thought. The ultra conservative one, which is mine. I like to be very, very conservative. But then there is the one that is probably a little bit more aggressive, but it's not aggressive to the extent that it would worry me. That viewpoint is, until USCIS actually revokes my EAD, I will continue using it. So that's your choice. Personally, in your circumstances, I don't see what else you've got to lose. I mean, you feel okay about it, go ahead and continue using it if you want to be aggressive. If you want to be very conservative, then don't use it. Next question is from MTTR 1975 about the AC-21 restrictions. He wants to know that he knows that they can move their jobs using AC-21. They have to be same or similar. Are there any other locations? I think what you want to know is there any location restriction? And the answer is no. You can move anywhere within the United States when you do an AC-21. Salary. Well, if you look at the May 2005 memorandum from Bill Yates, which has the most comprehensive discussion of AC-21 laws, because we never got regulations from USCIS, all we have is a memorandum, a couple of memoranda actually. The May 2005 memorandum says that if the salary is too different, that might be, not always, that might be an indication of the jobs being too different. I don't think that's a good criterion. I don't worry about salary difference too much. But each case is different. You should get your lawyers to look at your particular case. Okay. Next question is Satya KB. Satya wants to know. He's done the AOS filing himself, and they've done a porting of the date. And there was their case was stuck for a while, but once they got it unstuck, they received an RFE for the interfiling. And now the question is, will I be able to apply for AP and be eligible to travel to India upon approval? And the answer is, if everything else is okay, you have no other problem in your background, definitely, why not? If your priority date becomes current, actually once your 485 is properly filed, you've got your advanced parole, you've got your EAD, you should be able to travel. People who cannot travel are those who have some irregularity or unlawful presence issue, or something like that which makes it not possible to travel without major problems. If yours is a simple, straightforward case and you're doing interfiling and USCIS records obviously are showing that they've sent you an RFE and they are entertaining your application, I don't see any problem in traveling. DG Thomas, there's a problem in the birth certificate date of birth and the passport date of birth. Wife is becoming a citizen next month. He's currently on H-1B. He was preparing his papers for green card and found that there's a different date in birth certificate and there's a different date in the passport. There was some clerical error in educational documents which were used when applying for passport. So what they are doing is he's actually applied for a court order in India, I'm assuming, to change the passport. It can take several months. Can I apply for a green card? Definitely. What you should do is apply for your green card with the original date of birth and supporting documents. Don't provide anything more than that. Let the government come back and question you about the passport. When they do, send them a copy of the court proceedings that are in process in India. That should be enough. Okay? So no worries, apply for your green card. Next question is Babu, SYDU Babu, Saidu Babu. Can I transfer my cancelled H1B? So this is what his situation is. He is working with some organization in India. That organization processed an H1B. It got approved. Then he left that company and joined B. Never came to USA. I just have the receipt number. If your H1 was processed within the last 6 years, I think you are entitled to get your H1B while being exempt from the quota. I think you can. Okay. There are some other questions on H1B. I remember reading them this morning. There are some other questions, similar questions on H1 that was not used, previously approved. These areas are admittedly gray areas. I have never seen very clear statement of law on these issues. But in my view, you should be able to get H1 without being subject to the quota, if your H1 is approved anytime in the last 6 years. Minaras has another similar issue about the birth certificate and N400. So the full name as it is spelled in the passport and green card is different from the birth certificate. It never was any problem applying for a green card or any immigration visa. Okay, the middle was never used except in the school certificates. Now they had a citizenship interview. This issue came up, and they are doing another FBI check on the other name as well. Okay, is this going to be an issue? I don't think so. Typically, what we do is when we see more than one name used in somebody's background, we put that in the other names used column in the government paperwork. And if there is no such column, we put it in a cover letter. So the government knows by the time they do the FBI check, they have cleared all the names. Part of the FBI check is checking on you by name. Okay, so this is not something which is non-routine. I don't think this should cause any major issues for you. Sumit Sahani 99, talking about green card EB2 eligibility. You've got your bachelor's degree. Actually, give me 1 second. I think I have a. All right, just trying to check. I got a ping on my cell phone. Sometimes people have last minute questions and they send us a ping, especially our clients. So, okay, coming back to the issue of green card EB2 eligibility. So you got a bachelor's degree, which is a 4-year degree. Okay. Now you've got 5 years of experience, but one of them is with the employer who's applying for your green card. You can go for EB2 if the experience that you gained while working with this employer is more than 50% different than the job being offered. For example, you are a quality analyst information technology, but the green card job could be for lead quality analyst, where instead of doing all the testing yourself, you are doing, let's say, advanced testing, white box testing, you're setting up test plans, you are guiding team members in how to do appropriate testing, you are setting up best practices. Now that's a more than 50% different job. In that case, you should be able to file EB2. Okay, so even though you have 1 year with the same employer, you can use that experience. Phukre, that's an interesting name. I haven't. Phukre is a very Punjabi / Hindi slang word. with some interesting connotations. I haven't heard that word for a long time. So Phukre says applying for H1B. So he worked for 3 years on H1B. Then he left for India. Can he file for an H1B? And the answer is yes. I think you are excluded because you were on H1 till 2009. So you should look into something called remainder option. Remainder option, which means if you want to be exempt from the H1 quota, you will have only 3 years of H1 left, or whatever time you have on your H1 minus the time you already spent in USA on H1, and you should be exempt from the quota. I think I covered all the questions. If I were you, I would go for the remainder option and apply for a green card as quickly as possible. That way you can keep getting H1 extensions beyond your 6 years. Next question is from rr.nals, which says, after getting H1 approval notice, do I need to get stamped in home country to work? You know, it appears to me that you've got your H1, but you don't have a change of status. If that indeed is the case, you will need to get it stamped. It doesn't have to be in India. It can be in a third country like Canada or Mexico. And you can, if you don't have change of status, you will need to get change of status. Of course, you can file for change of status within the United States, but that's like redoing the whole H1. So the case gets reopened. A lot of people are uncomfortable with that option. Your lawyers should help you decide what is best for you. But certainly, if you have not received change of status, you cannot work on H1 until you do. Very similar question to the H1 quota, IMQ7. In 2008, employer A1 filed for an H1B. It was approved. Good till September 2011, but I did not get it stamped or use it. In 2010 he's been working on L1 since then. Can the new employer file under quota exempt? In my view, yes, they can. Does it matter if my new H1 will be filed for a different occupation? It does not matter. It does not matter. Let a lawyer look at all your timelines before you file it, but at least it's worth exploring. I think you should not be subject to the quota. Okay. V3S. Now what has happened here is that we've got two kids, twins, who are 10 years old. They are in India. When they went for H4 visa stamping with their grandparent, the consulate turned them away saying, your parents need to come. Parents are here. What do we do? What you should do is, you should send an email to the consulate, explain the circumstances, and let them know that if you need any power of attorney or some kind of authorization, we can send that from here. But we are both the parents here in the United States, and their acting guardians are their grandparents. I think they should be permitted. So send an email to the consulate. They're usually good about responding to emails. Next question, H1B, H4. I think I have actually a copy of this. Thank you for helping the community. Yeah. H1B, H4, this user had an odd problem. He was not able to see his own posting. Monica, our CTO, said she was able to see it. I was also able to see it. So he sent us an email. I have his email as well, but I can see that it's the same question. Okay, so no worries, I've got it, H1B, H4. So current situation is H1B visa completing 6 years in Jan 2014. I-140 EB2 approved, priority date Jan 2012, Indian citizen. Actually, it's the country of birth that matters, not the country of citizenship for priority dates. So my plan is to switch to another role internally within the same company from IT consulting to IT architecture and sales support. Does green card have to start from scratch? It may, because if the job is substantially different, you cannot take advantage of AC-21 because your 45 is also not filed. Plus the job may not be similar. So best thing to do is to start a second green card and then transfer the priority date. The jobs can be totally different, no problem. Can I still get a H1 extension? Yes, you can. No complications that I see. And you should be able to get 3-year H1 extension because your I-140 is approved. If the date becomes current by any chance, will I get EAD? Look, you've got position X for which your H1 is already approved and your green card is already approved. And you got position Y to which you are going. If you are working on Y and the priority date becomes current and you do retain the intention of coming back to X if necessary, the first position, you can file your green card, file 485, and then you get your EAD. Okay? It's a matter of intention, both employers and yours. Third and fourth questions. Third question is about what happens with the law if the law changes. I can't comment about that. There's so many things up in the air. And the last question is about the H4 regulations, which are pending and they'll stay pending for a long time, from what I can see. So I really can't comment about potential laws. I can only comment about what's happening now. Okay, actually you posted the same question twice. I can see both of them. No worries, that has been answered. So Ketan says his user ID is send to Ketu. Changing employer on EAD with H1B as backup. Current company has filed green card with manager job title in 2008. In my next job, if my title is director with base salary of much higher, see, first of all, 2008 to 2013, 5 years, if your salary increased 50-60%, I think there's a good argument that that's not abnormal in the IT industry. Okay, so really it's not easy for me to make a snap judgment on this. I would have to look at the two jobs, the manager's job, the director's job, to form an opinion whether they are sufficiently similar. So let's assume they are sufficiently dissimilar. You can do a new green card through the new employer and transfer your priority date. That might be a good way to do it. You have questions. One, can I make new employer file AC-21 portability with USCIS? You can. Given there is a big difference, that's something we have to assess. Your lawyer should assess that. They should tell you whether you should be filing AC-21 or not filing AC-21, and whether the jobs are similar, dissimilar. Difficult for me to make that decision. Should I do an H1B transfer? I think that's always a good idea. If you have the option, don't let go of your H1. Keep your H1 as a backup. It's usually a good idea in my view. Okay. Now, what if I skip AC-21 portability in step number 1, but doing H1B transfer in step number 2, which is nothing but informing USCIS about changing employer? Does that cause an issue with pending green card processing? Yes, it can. If USCIS is awake and they look at this, they could question it that you are changing jobs but you've not filed AC-21. Remember, there is no law that you have to file an AC-21, as you know. Okay. So difficult for me to assess. This is a very strictly fact-bound question. There is a possibility you'll be able to do a successful AC-21. Page 123. This is a very common problem, excuse me. Currently on H1, they have signed an agreement which requires them to pay liquidated damages. Let me explain to you what liquidated damages are. You'll see these contracts. They say all the time, if you leave our employment within 2 years or 1 year, you will pay us 10,000 towards attorney's fees and legal expenses, 5,000 towards training, and 7,000 towards replacement of your successor, etc., etc. A liquidated damages clause is that where a certain sum has been assigned to an event which will occur in future. So if you leave my job, you have to pay me $23,000. The event is in the future if you leave my job. Normally, the normal rule of law is somebody hits me on the street, break my leg, whatever damages I incur, I lose my salary, I have to pay medicals. I then demonstrate to the court what my damages are and I get paid those damages. So normally what happens is you establish the damages after the harm occurs. Okay? But liquidated damages are a future projection. If you leave, that's how much you've got to pay. The idea is damages are uncertain. We don't know how much it's going to cost us. They are not a penalty. We are not trying to hold you from leaving us, which can be in a lot of the employment contracts. And parties have had a chance to consult their lawyers and they've agreed upon a sum. That's what a liquidated damages clause is. I have written an article, I think it was last year, for American Bar Association, American Law Institute publication. And that article is available on our website. If you go to immigration.com, look at About Us, and look at the articles written by Rajiv, that's me. One of the most recent articles is on liquidated damages. It's a good idea. If you ever get sued on that, take a copy of that article and show it to your contract lawyer. Show it to the lawyer who's representing you in the litigation. Because immigration law creates certain constraints that when employers try to enforce liquidated damages clause, they could be in a lot of trouble. Okay. So his question is, can I file a complaint with DOL? Definitely. Definitely. You cannot file any complaints in India because DOL does not extend to India. As to the options to contest the case, what I want you to do is take a copy of that article, because that article sits in between or at the boundary of contract law and immigration law. So your lawyers, if you hire one who litigates, will know about contract law, but they will not know about immigration law. When they read what I have written, it's written with an eye towards people who don't know immigration law. So they'll be able to understand how to make it work for you. Okay? That's what I would suggest. Arjun, who is Arjun G, green card processing while working in USA versus India for the same company. The way it works, Arjun, is when you process a green card through perm processing, step 1 and the step 2 are the same no matter where you are. So perm, I-140, same. The last step, which is I-485 or consular processing, depends upon where you are. If you file I-485, you have the right to do AC-21. Consular processing gives you no such right. You also get work authorization. Consular processing gives you no such right. And for consular processing, you'll be interviewed in your home country, which is India. So you'll go to the US consulate in India, whichever is closest to you, and you will get your interview done there. That's the difference. Theoretically, they're both possible, they're both good, but it depends upon the individual case. Your questions that are two with several subparts. Can I do a job transfer for the same company in India and still ask my company to continue the green card? Yes, you can. Not I-485. For I-485, you have to be physically in the US. You'll do consular processing. When I'm in India, can my H1 be kept active? Yes, it can be. You don't have to be paid. They just don't revoke it. Two, if my priority date becomes current, is the following true? After 3 months from filing I-485, I get EAD. Yes, if you are in the United States, definitely. If the priority date is current for 6 months, I will get my green card. No guarantee. If your case is fully processed in 6 months or however long it takes, then you will. If I get EAD AP after 3 months from filing I-485 and the PD becomes retrogressed, do I still have to maintain active H-1B? You do not, but it's a good idea. Once 485 is filed, even if the priority dates retrogress, you keep your EAD and your AP and you keep renewing them. Okay? So that's not a problem. Actually, this is H1B H4 again, a third posting. So every time you posted, it showed up. Okay? And now this is the last question that was posted from Hem Prakash. Hem says, I'm on a B2 visa. Can I convert to F1? What I remember, there is actually a regulation now, last few years, there's a regulation that says any person who enters on a tourist visa, B visa, and they want to convert to an F1, they should have declared their intention to do so at the airport. I don't know if USCIS themselves are aware of these regulations, because I've seen them adjudicate cases where there was no declaration. But there is a regulation. I've seen them refuse cases because such a declaration was not made. Changing from B to F or H1 within the United States is always a bad idea, because it can be treated, your entry into the US can be treated as fraudulent or misrepresentational, in that you came in saying, I'm just going for a brief time on a tourist visa, then you convert it to a long term, it looks like you had a preconceived intention to do so. Can my brother sponsor my education in US? Yes, they can. So if I were you, I would probably go back and apply for a student visa from India. Okay, I'm done with my questions that were posted. Anybody who has posted a question and has a follow-up question on what I've discussed, only people who have posted first, please press *5 on your phone. *5. 1 hand, 2 hands, 3 hands, 4 hands. Okay, I'll get started in the order in which you called into this call. Missouri, area code 816. Go ahead, please.
Hi, Raju. This is Ketan.
Hi, Ketan.
And question is, I'm working in the same field, and my first question was related to AC1 portability. And my first employer cited as a manager, and in the same company, I got a promotion as a senior manager. And in the next company, I'm joining as a director, even though roles and responsibility is identical to a senior manager position.
Ketan, 1 second.
Yeah.
1 second. Was your green card done as a senior manager or as a manager?
It was done as a manager.
So we have to compare manager with director, not senior manager with director.
Okay, got it. So based on my high-level discussion with my current lawyer, she's saying 8021 can be filed because it's a promotion and I'm working in the same field.
No, you must have misunderstood your lawyer. Well, maybe she's making a point that has been stated a little bit differently. So, is AC21 possible? That is completely a fact-bound question. If she has compared the two jobs and she finds they are substantially similar, you should be fine. But really, I can't comment about that because this is a question that can be only determined after reviewing the two cases. Okay.
And another question is, I'm filing H1B as a backup. So should I be joining the next employer only if I receive the receipt notice?
I would be, if I were you, I'd be joining them only after I get actual approval of the H1.
Okay.
Okay?
And very last from my side, you suggested a new employer to file a new green card
Right.
based on the current salary, job description, but is it doable to connect back to my older I-40 just to retain the priority date?
Absolutely no problem. It's done all the time.
Okay, so I assume filing the new GC and labor might take 8 to 9 months. And during that process, do we need to file 1821 to inform USCIC, or we can start filing the green card as a whole new process without informing USCIC about anything?
Let your lawyers make that decision for you. There are pros and cons to both. Depending upon which direction appears to be safer, that's what they should be doing. Most cases, I'm inclined to file the AC-21. Most cases. Okay.
Raju, I did not get your last comment. So
I
you
said-
are saying the best practice.
It's in my mind, in most cases, filing an AC-21 is a good idea. Most cases. Okay.
Even though a new company is doing a green card from there.
Even though they are doing a new green card, yes.
Okay, got it. Thanks.
Good
I'm
luck.
done from my side. Thanks for your time
My
and
pleasure.
nice comment.
My pleasure. Good luck, sir. Okay. Let us see. Tennessee, area code 615. Go ahead, please. Tennessee.
Yeah, this is in continuation to question number 12.
Number 12.
This is regarding, I got my H1 visa from an employer A in March 2012. I got the stamping done on the passport.
Right.
After that, my current employer gave me an L1. So with
Right.
the existing employer.
Sure.
And I came to US L1A. And
You don't have to repeat the question. I have it in front of me.
okay, and now I have an offer from the other employer. He's willing to do my green card processing. So can I utilize the same non-exempt quota of H1?
Yeah, I already answered that question. Maybe you were not on the call. I already answered that question that in my view, yes, you should be exempt from the quota.
Yeah, but the only difference is when I went for an L1 stamping, they put a cancel stamp on the H1.
That makes no difference. That
And if the new employer wants to process for the green card, he has to go through the H1 route. That means convert from L1A to H1 and then file for the green card.
no, they do not. They can file for a green card directly. You don't have to be on H1 to file a green card.
Okay, so under the L1 conditions itself, they can file the green card.
You are working for one employer on L1.
Yeah.
Another employer can start your green card even though you have not yet joined them.
Using the earlier H1 quota of another employer.
H1 quota has nothing to do with green card.
Okay, then it can be filed in EB1 or it has to be filed in EB2?
EB2. L1A, EB1 can be only filed if you are coming through the same group of companies through whom you did your L1.
Okay, so in this case, what will be the time duration? Suppose he starts it tomorrow, what is the time duration?
Well, that's something you can assess from the visa bulletin. Anywhere, depending upon EB3 or EB2, anywhere from 5-6 years to 8-9-10 years.
Okay, but the moment he files, I can join him.
You're confusing green card and H1. These are two different things. You will join him based upon your H1. The green card will be filed based upon an expectation that after or before the approval of the green card, you will join them. So if you want to join them next month, you have to do an H1. If you want to join them 8 years down the line, you do a green card. I know you haven't understood it, but that's okay. Let your lawyers explain it to you. These are two totally different things. So, in short, your H1 should be quota exempt, but you don't have to file it to start your green card.
Okay, so if the new employer wants, he can just change the name on the H1B, which was there earlier.
It's not changed. They have to file a new H1, but it's quota exempt H1.
Okay, so what I was trying to ask is, if they file a new H1, what is the timeline by which I can get the H1?
If you do a premium processing, maybe 4 to 8 weeks, 10 weeks, depends upon what kind of questions the government asks.
Okay.
Okay.
Thanks a lot for it.
You're welcome. You still have some very basic issues that are not quite clear. So make sure you make a list of your questions, gather some more information. Feel free to come back again 2 weeks from now, or get together with your lawyers, get all the questions answered. But basic bottom line is, H1 is not subject to the quota. Green card can be started anytime you like.
Okay.
All right?
Fine.
Good
Thank
luck. You're welcome. Okay. Let's see who's next. New Jersey, 908. Go ahead, please. New Jersey, 908. 908-673.
Hi, Rajat, this is Kumar from New Jersey. Is the new question not posted on...
Okay, sit.
No.
No, please. Wait until I call for new questions, okay?
Okay, no problem.
Just a moment. Oh, darn, I keep messing this up. All right. Mute. All right, let's see. Who's next? No new questions, folks. Just the questions that have been posted first. Baltimore, Maryland, 410. Go ahead, please.
Good afternoon, sir. Please, yeah.
Good afternoon, sir. Which question?
Regarding question number 5.
5. 1 second. EB3 to EB2 ported. You're representing yourself, so you wanted to know if... Yeah, Satya, go ahead, please.
Yeah, right. Today I am correct. What the trouble is like, because of the status, even after responding, it is still not updated. So, under this situation, can I submit an AP renewal? Like,
I don't see why not. Because everybody knows, at least I hope that everybody knows, that their website updates are neither current nor reliable. So they try to make it as current as possible, as reliable as possible, but they are not always successful.
okay.
So go for it.
So that means I'll be able to submit it, and then in case if I get it, then I can travel.
That is correct. Yes, sir. Unless you have something negative in your background, like unlawful presence or something, most of the times it's no issue traveling once you have your AP.
Okay. Yeah. Thanks a lot, sir.
Oh, my pleasure. Good luck. Yep.
Yeah. Is there anything that we need to be cautious with the existing situation? Like, if the status is as it is, and if you are returning back at the time, do we need to face any extra troubles?
No, there is no problem with that. No.
That's not a problem.
Yeah,
Okay.
as long as your background does not have any unique facts, it's just a normal employment-based case, you should not have any problem traveling.
Okay. To the extent I remember, it's all clean. Very simple.
Good luck to you.
Okay. Thanks a lot, sir.
You're welcome. Bye-bye.
Bye.
Another one from New Jersey, area code 732910.
Hi Rajiv, this is Jiva here. I have a little tricky question. Like, I was on H1.
Hang on 1 second. No new questions. Sit tight. I'll get back with you. Next one is Pennsylvania. 570. Go ahead, please.
Yeah. Hi, Rajiv. This is regarding question 17 for the H1 sponsorship and the liquidation damage.
Oh yes, liquidated damages. Liquidated damages.
Yeah,
Yeah, liquidated damages. You got it. Yeah, go ahead. I'm listening. Did I lose you? Hello? Okay, I'll leave you open. Maybe you just faded out. California area code 858. Go ahead, please.
Yeah. Good afternoon, Rajiv. This is regarding question number 11.
11. Okay, 1 second.
Yes.
$11. Why am I lost? Here it is. Yeah. Okay. Do I need to get stamped in home country after I've got my H1B approval? Go ahead, ma'am.
Yes. Yeah, actually, the first thing is I worked in L1 through an Indian company in 2007 for 6 months. So I got SSN. But after that, I went to that project is only for 6 months. So after that, I went back to India and I worked for the same company for a year. And then I got married and I came here in H4 in 2008. So till now, I'm in H4. But the thing is, last year I went for a vacation and I entered US with my old passport, which is valid only till this September. So they gave me an I-94 only for till September for this H4. But now I got I filed for an H1 and it's approved and I got the approval notice. And also I got an I-94 with that approval notice. But in that there is no dates for that. So
okay, hang on 1 second.
No.
Hang on 1 second.
Yeah.
When
Yeah,
when you get an I-94 and it has no dates, it's quite obvious this is an error made by USCIS.
Okay.
So if USCIS has made an error, you should be able to get that corrected very easily. What you do is you have your lawyers call the USCIS customer service, explain to them that the change of status was approved but the I-94 is defective.
Okay.
So you should not have to travel outside USA to correct this problem. This appears to be a USCIS error.
No, I'm sorry. But what my consultation lawyer is telling is because I have an I-94 with H4 only valid till this September, they are and they filed my H1 only with this I-94. So they are asking me to travel to India because it needs to be stamped only in the home country. Is that true?
No, that is also not true. Look, here is I think what is happening. I'm making a guess here. I'm assuming that your lawyers are competent, smart people, and they are not making any legal errors. I think what they're saying is because your H4 ends before October 1st, so there is a gap of about 10-12 days between when your H4 expires and your H1 kicks in. What they probably are saying that that's the reason you did not get an I-94. But you know, once you have received an I-94, by the way, I know many people in this situation who received an I-94 beginning October 1st, no problem at all. Okay? So I am not clear whether your I-94 is a government error or what the problem is. So first thing you need to do is sit with your lawyers, have them call USCIS customer service, make sure there's no government error. If there is no government error, then you should try to make an appointment in Canada or Mexico and see if you can get your stamping done there. Bear in mind, you have to get a visa to Canada if you want to go to Canada. So that itself might be another issue. Keep this in mind.
Okay. And also my H4 is valid till next year. Only my I-94 is expiring this September. Hello?
I'm trying to to understand what your question is. I understand what your situation is. What is your question?
Okay. I think my H1 is valid till March 2014. Only my I-94 is expiring next month. That
Right.
is September.
Right. Ma'am, your case should be discussed with the USCIS.
Okay.
Your lawyer should be
Okay,
talking
yeah.
with them, because there is a lot here that can be argued, and I think you
Okay.
should have received your H1 within the United States. By the way, let me also tell you this, that India is one of the few countries that is exempt from the requirement that your passport must be valid 6 months beyond the reason for your entry. India does not have that requirement. So they should have given you an I-94, or at least it should be argued that you were entitled to your I-94 all the way to March 2014. If CBP made a mistake, you should not have to suffer for it. You should have received your H1 change of status within the United States.
Okay.
Okay?
Okay, thank you.
You're welcome.
Thank you, sir.
Welcome. Okay, last call for California. No, I'm sorry, Pennsylvania. Area code 570, Pennsylvania.
Yeah, hi Rajiv, can you hear me?
I can hear you, sir. Go ahead.
Yeah, sorry. It was actually me. I think I was trying to talk to you previously and my line got disconnected.
No problem. Tell
So
me.
regarding the H1 liquidated damages.
Yes,
So
yes.
What I was thinking is, basically, I read some article where it seems that the DOL laws are more employee friendly than employer friendly. So now I did hear your suggestion where you mentioned that I should basically the article that you have researched on the same topic, along with the agreement that I have with my employer right now, I should be using that and taking it forward to the DOL. The only thing I was not sure is, do I need an attorney representation
No.
to handle my case?
No, not at this point. Have you been sued?
No, I mean I haven't. I'm just kind of exploring my options. I'm nowhere close to getting it started as of now. I just wanted to understand the rules and the regulations better.
See, I know that sometimes Wage and Hour Division of the Department of Labor says until the employer tries to collect on this, we cannot intervene. But it doesn't hurt to ask them.
I'm sorry?
I said Department of Labor usually, Wage and Hour Division of the Department of Labor is responsible for enforcing these provisions. Normally they don't like to intervene until and unless employer tries to send you a letter or a lawsuit saying we want this money.
Okay.
So,
Now,
but it doesn't hurt to ask them anyway. So go ahead and file the complaint. At the most they can say, well, we can't intervene until you get sued. But at least you would have, kind of established a record for it. No harm in trying.
Okay.
And you do not need a lawyer for this part, no.
Okay. And I mean, I did check with my current lawyer. They said they cannot represent me if I would like to, because they are already having a relationship with my current employer.
Well, that's called conflict of interest. We would have it too. If we filed the H1, represented both you and the employer, we couldn't represent one against the other. We couldn't sue you if the employer asked us to. By the same token, we couldn't sue the employer if you asked us to. You are both our clients, so that's understandable.
So, sir, Raju, I mean, would you be able to represent in such cases if at all?
You see, there are two different issues involved here. First of all, I only do federal court litigation. I don't go to state courts. I don't go to immigration courts. This will be a state court litigation in all probability. Okay, so you will need a lawyer in the state court. That lawyer will need to, if you get sued, that lawyer will need to be educated about the special immigration considerations. And for that article is there. That article has been downloaded many times by lawyers all over the country who have been stuck with this strange situation. So if you do get sued, I hope not, if you do get sued, take a printout, have your lawyer review it, and that should be enough for them to be able to represent you effectively. They're welcome to call me. I'll be happy to share whatever I know with them. But I cannot do anything for you because this will be a state court litigation.
Okay, thanks.
Okay, you're welcome. All right, guys. Okay, anybody has any questions, new, old, anything at all, press *5. *5. So we have only 3 more questions. 3 more questions. All right, let me get started with New York first. Well, 4 questions. New York, go ahead please, area code 212.
Hi Rajiv, thanks so much for actually taking this call.
My pleasure.
My case background, I have 3 years of BSc and 2 years of PGDM with 8+ years of progressive experience.
Hang on 1 second, 1 second. 3 years of BSc you said?
Yes.
And 3 years of postgraduate what?
2 years. 2 years of PGDM.
Where is it from?
India.
Which university, which institution?
It was an autonomous university.
Which? I'm sorry?
It was an autonomous university.
Autonomous university. What?
Autonomous university.
Give me the name. Is that the name of the university?
No. That's just the profile. But it's IIM. It's MM. It's Indian Institute of Modern Management.
Indian Institute of Management. IIM or IIMM?
IIMM.
2 M's.
Yes.
Okay. I've never heard of this. I know about Indian Institute of Management. But okay, so keep going. And you have 8 years of experience.
Correct. Out of which the 5.5 years was with employer X in the US. The 3 years were in India. So the 5.5 years was with employer X in the US.
Okay.
Who filed for my green card under EB3.
Okay.
And my 140 was cleared with a priority date of June 2007.
Okay.
Yeah. I changed jobs after that, and my now employer Y, I've been with them for 1.5 years.
Okay.
My ex-employer, he wants to revoke or withdraw the GC application since
Okay.
I'm not working for them anymore.
Sure.
Now my H1B from my current employer Y is valid till Jan 30th, 2015, which is post 6 years of extension.
Okay.
Employer Y, my current employer, is also in the process of filing my green card application.
Okay.
And he wants to do it under EB2. But the educational verification states that I am eligible for EB2. But it comes with a risk, with a possible RSC due to the combination of degrees being equivalent to US bachelors. And in case of an RSC in the labor, the H1B cannot be extended unless there's an approved labor. Bottom line.
Or unless there's an appeal.
Correct. Now my question to you was, 1, can I continue to keep my priority date, which is June 2007, even though the EB3 application from the employer X is either revoked or withdrawn?
You do. You keep your priority date. No question.
Perfect. The second question is, should I file under EB2 or go safer with EB3 based on the educational background that
File under EB2 with language in the labor certification that makes it possible to drop back to EB3 if EB2 is not approvable. Your lawyer should be able to figure that out.
What they mentioned to me is they enter that language, the chances of going with EB2 becomes lower.
That is not true.
That
is not true.
Okay. Cool. That helps them. And the priority date porting from employer X application to the new application filed by the employer Y, that can be done on an EB3 filing or an EB2 filing. It doesn't matter what my current
Yes,
employer
portability can occur to EB2 or EB3 even though the underlying I-140 was EB3.
Okay, and my final question, I think you answered this already, but if there is an RFC on the labor, say I have gone with EB2, if there's an RFC on the labor, then the H1B can still be extended if we've answered the RFC and we're waiting for a confirmation or something like that.
The way it works is your H1 can continue to get extended once 1 year of pendency has come and gone and something is pending, whether it is an appeal against a denied labor certification, an I-140 is pending, or an I-140 appeal denial and then appeal is pending, an I-140 appeal is pending. So if 1 year has come and gone and something is pending, you are entitled to your H1. If the I-140 is approved, you'll get 3 years, otherwise you'll get year to year.
Correct. But if the GC filing happens only, say, with all the documentation and everything, it's only done by Jan of next year, essentially that leaves only 1 year on my current H1B. In that case, by mid of next year, if we get a failure or we get an RFC, then that puts the whole situation for H1B extension.
Nothing you can do about that. You can only plan for whatever is presented to you in the best way possible. There is no way to cover the eventuality where the green card filing is done too late and I-140 is not approved. That means you would have to be outside USA for a certain number of months.
You'll have to be outside the country for a certain number of months.
Or convert to another status within the United States.
Okay. And how long do I have to be, just worst case scenario?
That depends upon the gap. How much is the gap between when the PERM was filed and when the H1 expires?
Interesting.
Okay.
Okay, cool. All right, sir. Thank you so much.
You're welcome. Good luck.
Thank you.
Okay. We have 3 more questions pending. That's all I will do, folks. So 3 more questions. You have already raised your hands. I'll make sure I finish them, but then we won't do any more. California, area code 510. We can all hear you.
Okay, hi. Are you? Hello?
Yeah, I can hear you, sir.
Okay, so I have a couple of questions because I'm applying for my naturalization.
Okay.
And, there's one question that says...
Hang on. Before you do that, stop right there. I will not help anybody in filling out forms. That is a problem for us. That's a legal malpractice waiting to happen. I can answer generic questions. I cannot help you fill out the form. So ask me the question in a generic way.
Wait, I don't understand.
I cannot help you fill forms. Look at the last page of the form. It tells you, has anybody helped you fill this form? If they have, they should sign here.
Oh, I see.
I can't help you fill forms. You have any general questions, I can answer them. I can't help you fill forms. But you can ask me a general question. Same question can be asked in a general way.
Oh, okay. So...
I'll give you an example. Ask me what is the question that you have a problem with.
Okay, so... Because there were 2 years that I didn't file for my income tax.
Okay.
Since becoming a permanent resident, and I understand that I have to indicate that, correct?
Look, whenever you fill out any government form, if there is a direct question asking you a particular fact, you have to disclose that fact. You cannot conceal it. Second...
Okay, I understand.
Right, and second, it's always permissible to attach an explanation. So if something needs further explanation, you can attach an explanation. For example, if there were 2 years you didn't file taxes, third year you filed and paid your taxes, I think that covers it.
Yes, and so that means I disclose that
Anything
this.
that is asked should be disclosed, no question about it.
Okay, got it. And I also explained that I was earning too little of an income at the time, correct?
Yes, if you were earning less than the standard deduction, taxes are not required to be filed. A return is not required. I mean, you can check with your CPA what they say, and you can get a letter from them attached that as well.
Okay, got it. Okay, a few other questions.
Yeah, I don't know whether tax returns are required. I'm not a tax expert, but you have to check with your CPA, and I think you'll be okay with that.
Okay, well, is there a difference with being charged and convicted?
Yes, charged and convicted. For example, if somebody arrests you and says you've committed a crime and they take you to court, that's charging. But the court says, okay, you did not do it, there's not enough evidence, whatever the reason is. If you get acquitted, that's charged but not convicted. Okay?
Okay, so here's what happened. Back in 2008, I was cited by a police officer for open container in public. You
Sure.
understand?
Sure, yeah, I understand.
Okay, so
You will have to reveal that.
I was,
You will have to reveal
yes,
that.
that's,
Yeah.
that I agree with. So I was scheduled to court like in a month or so, and I pleaded guilty, and they asked me to pay a fine of around $200 to $300. So that means it's both charged and convicted, correct?
That is correct.
Okay, and I'm wondering if that will be counted against me.
It can be. It depends upon how many of these incidents you have in your past. Usually, if it is more than 5 years ago on the date you file for your naturalization and it looks like a misdemeanor, they may not ask you any questions about it. But they can if they want to. So, if you can wait 5 years from that day, that might be better for you.
Wait, if I what?
Wait 5 years from the date of the conviction, you might be better off.
Okay, so it happened August 15th, 2008, so that means I should file the day after?
You should file more than 5 years after, which means file in September, October, you should be okay.
Okay, got it.
But they can ask you about this incident. But I think on the N400, you only have to disclose in the last 5 years.
Last 5 years?
Yep.
Okay, so that means if I file September, I'm okay with it.
But look at the language of the form. I haven't filled a form in decades, so I don't really know what the question is. But on the N400, I think they ask you only about the last 5 years. Whatever they ask, that's how you have to respond. Yeah.
I have it with me right now.
Sir, I'm going to have to get back with you. Let me just finish the other two questions. You go ahead and marshal your questions. I'll get back with you, okay?
What?
I said marshal your questions, whatever you have. I'll get back with you. Let me finish the other two guys who are ahead of you. Be right with you.
Okay.
Okay. Yeah. Summit, New Jersey. Go ahead, please. 908.
Hi, Rajiv. Good afternoon. This is Kumar from New Jersey.
Yes, sir.
Hi. This is regarding my ED combo card. Right now, my 485 case in review, RFK review, because bunch of people, everybody got RFE during last month.
Okay.
So I submitted
Yeah.
everything, and I have my combo card valid till 2015 March.
Okay.
And if I'm planning to go for a short vacation to India during this month, if I re-enter August 2013, they give advance parole maximum of 1 year. That means till August 2014. Is it correct?
I think they give 2 years, but I'm not sure. From what I know, it's 2 years.
Okay. But in case if they give maximum of 1 year, so my multiple entry is valid till the new date, which is August 2014, or till August 2015, I can do multiple entry.
You can only enter the United States within the life of your advance parole, whatever time there is.
Whatever the time they gave in I-94, is it correct?
Whatever the time they gave on the advance parole.
Whatever the time they gave, it's not clear. Can you, whatever the time they gave on?
Advance parole document.
Oh, okay. So it says 2015 in the card. So
yeah, whatever the card says. Don't worry about the I-94. Whatever the card says.
Okay. And during my India visit, in case my RFE is denied or 485 is denied, so whether I can re-enter or do I need to do some other process in India?
They can decline entry if your 485 is denied. Just 1 second. One second. 1 second. Yeah, there was a lot of noise coming from California. I've just I've just muted them. Yeah. So if your 485 is denied, your advance parole should be treated as inactive. When you enter USA, they should deny you entry.
They will deny the entry.
They should. They should deny you entry. Yes.
Okay. In case if it is approved, if they show the green card during my India visit, so while re-entering, can I show the EAD or I have to have my green card?
You can show your AP and EAD combo card, no problem at all.
So my green card will not affect anything. So I will be in the green card status.
No problem. This happens all the time. Actually, I have a client who was stuck in Mexico. He's on H1 and his green card got approved. So he was very concerned, can I re-enter on H1? I said, absolutely. Because this is one of those loopholes in the law nobody has thought of. I'm gone and my green card gets approved. What happens? No problem. You've got AP, you can come in.
Okay. And the first question answer, it was not clear. You said whatever in my combo card validity period, even though they gave in I-94, the validity period of my combo card is the actual date, not the I-94 date. Is it correct?
That is correct. Yes, sir. But just remember,
okay.
You must, hang on, you must have that advance parole in hand. It shouldn't be like this, that you've got an advance parole till March, you applied for an extension and you left. You can't use the one that you will get after you've left. So far, USCIS will only let you use that advance parole which you have in your hand when you leave US.
Yes, that's correct. Right now the latest is 2015.
You're good till 2015 then.
Okay. And how do I know my combo card is multiple entry? Because the combo card doesn't say anywhere it is multiple entry. So how can I confirm that?
By default, it should be multiple entry. If you have any questions about it, make an appointment in the local InfoPass system and go talk with the USCIS.
Okay, to confirm that.
Yep.
Sure. So the final thing is, using my combo card validity period, I can do the multiple entry. That
is correct.
Thank you, Rajat.
You're welcome. You're welcome. Good luck. Okay. This one is also from New Jersey, area code 732. Go ahead, please.
Hi, Raju. Thank you very much for hosting community calls.
My pleasure.
I was working on US on H-1B visa for 5 years till February 2013.
mid of February 2013, I had to go to India on emergency basis because my father passed away. And my family situation changed after that. I couldn't able to come back to US on H1, but my family situation in US demanded me to come in. So I came on visitor visa, which I already got it in 2006, which is valid for 10 years. And it's been 3 months now. Now all the issues are solved, everything is fine. I want to go back to my H1B employer. He's still keeping my job. Can I just drive into Canada? I do have Canada travel visa and come back to US, re-enter US on H1B.
You have your visa stamp already on the passport?
Yes, I have valid visa, valid B2 and H1 as well as Canada stamp.
So you have a valid H1B visa on your passport?
Yes, valid until September 2013, but right now I am on B2 visa.
Okay, hang on. Your when was your H1 approved?
The first time approved in 2008 and then renewal approved in 2010.
Okay. Once it was approved, did you work on that H1 at all or did you leave?
Yeah, I worked on that H1 for close to 2.5 years.
Okay. When did you leave USA?
February middle 2013.
Feb 2013. I don't see any problem in using the H1 stamp to re-enter USA as long as your project remains the same, the terms remain the same, no problem at all.
Okay. Because my passport, Indian passport is expiring on September 1st, I got the B2 I-94 one valid only until September 1st. So can I get the Indian passport renewed, reissued, and then go to Canada, or I can just do a change of status here?
You can do both. I don't see a problem with either one of them. But get your passport renewed, it will save you some trouble.
Okay.
Okay.
Driving to Canada seems to be an easy option. Like just go in and then.
I think it's a situation that they will not be used to. It might take them a while to understand what is going on. But as long as your job remains the same and your entry on tourist visa was not in any way under any misrepresentation, I don't see any problem in coming back and getting an H1 entry.
Okay.
Okay.
So if my Canada visa is expiring tomorrow, if I couldn't able to travel today or tomorrow, can I travel to some Europe country after renewing my Indian passport, then come back, make a round trip to Europe and then come back to US on H1?
I think you can. I don't see why not. By the way, you wanted to hang on. You want it to be even clearer. You can try calling CBP, Customs and Border Protection, just to make sure they have no obvious problem with it.
Okay, I can check with them about my current status. Is it valid? And then I can check
No.
with them
You can just check with them about re-entering on H1 visa. I don't see any problem at all.
Okay. Thank you, Raju. Thank you very much.
You're welcome. Good luck, sir.
Thank you.
Okay, this will be the continuation of my last call for the day, back to California. Sir, go ahead. You had some questions that were left over on the N400?
Yes, correct. Okay, so this record would be taken against me. Is that what you're saying?
What I said was, from what I recall, any crimes that are convicted, that for which you've been convicted in the last 5 years, immediately before filing the naturalization application, are almost always questioned. But if it's more than 5 years ago, they may not question it.
And if they question it, would that mean they'll
is this the only problem you had with the law before?
Yes.
I don't think there should be a ground for denial of a naturalization.
And this one was a misdemeanor.
Yeah, I don't think this should be a ground for denial. Okay. I hate to hurry you along, but do you have any other questions?
That's all.
Good luck to you, sir. Good talking with all of you, and I'll see you again in 2 weeks. Thank you, guys.